Well, good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, June 29th, 2022. Time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janeka, as well as our General Counsel, Mary Smith. I'm John Neerman. For those who are joining us virtually, please remember to keep your microphones muted when you're not speaking. For those who are making presentations, please wait to begin until our General Counsel or I have asked you to begin speaking. On items where discussion or argument is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate your request. With that, I'd like to thank everyone for being present today. Ms. Smith, let's take up old business 1 with the enforcement docket and go straight to new business item 1.
New business item 1 is the application by the City of Bryan for a new TPDS permit number WQ00159300001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So for the benefit of those who are not familiar with our process, we have a 2-part analysis for considering requests for contested case hearings. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a hearing, and assuming that at least one requester has met those requirements, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets the hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. We refer to requesters who meet these standards as affected persons. So this is sometimes called an affected person determination. And we also sometimes describe affected persons as those people who have established a personal justiciable interest. To meet this statutory standard, a hearing requester must show that their interests are more particularized than those of the general public. In some cases, that's easier to show than others. For example, a person who lives right next door to a facility or who lives very near the discharge point or discharge route is very likely to be personally affected by the permit, while somebody who lives across the state or even across the country in another state is very unlikely to meet that standard. We look at a number of factors when making this determination. For example, for the type of permit that's before us on item 1, we would look at the type and concentration of pollutants in the effluent, the size of the proposed outfall flows, the size, number, and type of proposed treatment units, the frequency and intensity of use in the area, and I'm referring to the requester's use because they have to establish a personal interest. We also look at the requester's distance from the proposed facility or discharge point or discharge route. And because the impacts tend to diminish with distance, we look at distance together with these other factors. So there's not a predetermined distance. So colleagues, having belabored that explanation on this item, there are 10 requesters. As I read the facts, all but 2 have demonstrated a personal justiciable interest. Kenneth Davis never states how he would be personally impacted by the concerns he raises. His request is stated in terms of concerns for the public, and given that he does not live on or near the discharge route, I read his request as referencing concerns common to the general public rather than personal concerns. Georgianne Koo provides an address in the state of Washington and raises concerns common to the general public. The other 8 requesters live along the discharge route and raise concerns related to the discharge's effect on water quality of the stream that runs through their property and their groundwater wells. They also raise concerns about the effects of the discharge on their own health, on the health of their livestock, on the health of wildlife on their property. They raise concerns about nuisance, about the siting of the proposed facility in a floodplain. And given that these requesters do live near the facility or the discharge route or both, they in my view, raise specific personal concerns and should be entitled to a hearing. Their concerns, their interests are different than the general public. So I would deny Mr. Davis and Ms. Koo and grant the remainder.
I'm in agreement.
I am as well.
All right, turning to the issues, I've identified the following relevant and material issues to refer over: whether the draft permit complies with the Texas surface water quality standards and protects surface water quality, whether it is protective of groundwater and nearby wells, whether it is protective of the health of the requesters and their families, whether it is protective of livestock, wildlife, and aquatic life, whether it complies with the applicable siting requirements and other requirements expressed at 30 TAC Chapter 309, whether the anti-degradation review complies with the applicable regulations and the draft permit includes adequate nutrient limits, and finally, whether the commission should deny or alter the permit based on considerations of need, as we understand that under Texas Water Code Section 26.0282.
I'm in agreement on the issues too.
I think they captured all my issues.
Okay, and I think we'll probably need the full 180 days on this.
I'm in agreement. I've got a motion if we're ready.
Great.
I would move that we grant the hearing requests of Glenda Bricker, Ann Cecil De Leon, Jenny Gallagher, Neil Ryan Gallagher, David and Margaret Gale Hayden, Bobby Meyer, and Mary Louise Sims, that we deny all the other hearing requests and requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues. Number one, whether the draft permit complies with the Texas surface water quality standards and is protective of surface water quality. Two, whether the draft permit is protective of groundwater and nearby water wells in the area. Three, whether the anti-degradation review complies with applicable regulations and the draft permit includes adequate nutrient limits. Four, whether the draft permit is protective of the health of the requesters, their families, and other individuals who reside in the immediate vicinity of the proposed facility and discharge route. Five, whether the draft permit is protective of livestock, wildlife, and aquatic life. Six, whether the draft permit complies with applicable siting requirements in 30 Texas Administrative Code, Chapter 309, including adequate prevention of nuisance odors and vectors and compliance with floodplain and wetland siting issues. Seven, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code, Chapter 26.0282, and that we set the hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Commissioner, on the sixth issue, you mentioned including adequate prevention of nuisance odors, vectors, and compliance with floodplain and wetland siting issues.
Yeah,
Did you
did
mean
I-
requirements?
Yes, I did
Okay.
mean requirements. Wetland siting requirements, to be specific.
I second the motion as clarified.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 2 is the consideration of a request by the City of Ames to issue an emergency order to compel the City of Liberty to provide continuous and adequate sewer service. The City of Ames is the moving party and should be provided an opportunity to speak first, followed by the City of Liberty, any interested persons, the ED, and then OPIC. The City of Ames may reserve time for rebuttal. The General Counsel's Office recommends 5 minutes for each party.
Thank you, Ms. Smith. And I understand there's Mr. Nesloni here to represent. Good morning, sir. The first trick is to make sure that microphone is on. If you see a little green light on it, press the button that says push, and then you can introduce yourself, and we're eager to hear your comments.
Can you hear me? Okay.
Yep, perfect.
Commissioners, thank you for having me here today, especially on such short notice. My name is Trey Nesloni. I'm an attorney representing the City of Ames. Ames has requested an emergency order under Section 13.041H of the Texas Water Code to compel wastewater service from the City of Liberty. The City of Ames is a small town, less than 1,000 people, and they depend on their neighboring larger city, the City of Liberty, for wholesale wastewater service. Although our request is termed as to compel service, we actually want to maintain service. We have an existing contract with the City of Liberty that started in 2001 and runs through 2041. Now, the contract allows Liberty to charge Ames what's called additional service charges under 5.2C of the contract if we exceed what's called the total acceptable volume, defined as two conditions, a daily condition and a monthly condition. And that's really the subject of the dispute that we have with them, at least in district court. Around May of 2016, they started invoicing Ames for whether for the daily exceedances or the monthly exceedances, regardless of whether the other condition was met. So Liberty, again, sued in district court in Liberty County. They also sent us what I've called in the request a suspension letter threatening to suspend services in July 1st. So what we're really asking the commission is to maintain or order them to maintain service, at least through the litigation that's ongoing, so that we know whether we've actually materially breached the contract or not. Now, in their response, you'll notice they don't focus much on the damages issue. They talk a lot about their issues that they've had with TCEQ enforcement actions, and claiming that Ames, what they call I&I, inflow and infiltration, has led to those enforcement actions. But 3 points on that. If you look at the first enforcement action in 2015, it started in April of 2015, and Ames didn't have any exceedances, at least that Liberty billed us for during that month. So how can they say that we're responsible for that if we didn't even have these peaking issues during that month? Secondly, if you look at their petition, Liberty sues not only Ames but the city of Hardin. So it tells you right there they had it for almost the exact same issues. So how can they say that Ames is responsible? It could be the city of Hardin or one of their other customers. Third, Liberty makes a lot of points that we're not doing anything to address our issues with the system. That's not the case. Ames has already spent significant funds trying to address the issues. They obtained a Texas Department of Agricultural Development Fund monies and tried to do smoke testing and fix grinders and fix laterals. And then in April of this year, they executed an interlocal agreement for $2 million in CARES Act funding. So we are spending significant funds trying to fix whatever issues, whether or not it's really affecting their wastewater permit and their wastewater treatment. Finally, in their suspension letter, they talk about how we did not say that it was a valid contract. Understand that is an argument that we made under a plea to the jurisdiction in district court. That they didn't plead sufficient facts to show that we waived our immunity. That's something totally different than the contract. We think the contract is valid. We think it should be valid until 2041, and they should be compelled to serve us until then. Thank you, and I'll take any questions.
I've got a couple, even though this is a little bit outside the scope of what we're here to talk about today. Is there a long-term plan to address Ames's issues? Is there a project that y'all are moving towards, or how do we resolve this in the long run in the practical world, set aside the legal arguments and the damages and
Right.
all of that?
We have what we call a rehabilitation plan, which involves a lot of smoke testing and fixing problem areas that we presented as part of the CARES Act funding to get the CARES Act funding. And I can present that plan in response. I don't know all the details.
Yeah, that's probably not necessary, just, high level. The intention would be to make these corrections to your system, but with some hope of continuing to send Ames wastewater to the city of Liberty.
Correct.
Understanding that there are a lot of unknowns, but that would be a hope or expectation at this point.
Yes, that's Ames' hope. We want to be a good neighbor. We don't want to cause their system problems. But also, we don't have our own wastewater treatment plant. We do depend on them. So,
Okay. And then in Ames' view, if we were to issue this order, when should it begin and when should it end? Understanding that we also have, I think, some statutory limitations that we're operating under. If you've thought about it, I heard you say through the litigation, litigation has been ongoing for quite a while. It's hard to predict how much longer it may last, but.
it is. Yeah, I'm sorry. It's hard for me to say. Depending on, we were contacted before by the TCEQ's ADR department that Liberty possibly wants to move forward on a settlement. If that happens, it wouldn't take very long, I wouldn't think. But if we're dependent on the litigation and what happens there, 180 days, I don't know. That could
Okay.
be a guesstimate.
All right, understood. I don't have any other questions. Colleagues, any other questions?
No, thank you.
I had one question about the opportunity to avail yourselves of relief through that pending litigation in the district court. Have you sought injunctive relief in the district court to prevent Liberty from suspending or cutting off the sewer service?
We have not. The main reason was because we thought the bond that we would have to get would be extremely high. I mean, the damages they're alleging are $1.3 million. So it would cost the city of Ames considerable amount of money to try to seek such an injunction or a temporary restraining order or something of that nature.
Any other questions?
I think that's it for now. Thank you.
Okay,
Thank you, sir. Let's hear next from the City of Liberty. I understand Mr. Vassar is here. Good morning, sir.
Good morning. Commissioners, we appreciate the opportunity to visit this morning and address these important issues. Liberty welcomes the involvement of the Commission here. Liberty is the TPDS holder, and we take compliance extremely seriously. As Mr. Nisloni pointed out, Liberty has faced enforcement actions driven by excessive flows in the past. Not just one, but there have been two in the last 7 years. So Liberty takes its compliance very seriously. It is on the hook, not its customer Ames and not its other customer Hardin. Liberty is not the bad actor here. This isn't a new development. As has been noted, litigation's been going on for 4 years now. This is not something that's sprung on Ames as a surprise. We want solutions. We want regulatory solutions, and we want something that fixes I&I issues where you're dealing with 8, 9, 10 times peaking factors for a system that shouldn't have I&I problems that's only 20, 25 years old. It's a problem that's been ongoing. We're looking for a solution. Our ask today of the Commission is a couple things. One, we would ask you to deny the petition for emergency order. We recognize what's at stake here, but there are other options available that so far we've not seen that Ames has looked at for alternative haul and treatment of their sewage. Presumably they have looked at those. We haven't heard of it, but with an impending date of 2 days from now, we expect that they certainly should have. In the alternative, if the Commission does choose to issue an emergency order, we would ask that it come with conditions, with strings attached both on duration, but also with directive. The duration of no more than 60 days, it's allowed under statute and regulation up to 90, but also with a requirement that during that time, Ames both identify and implement alternate service options for its wastewater. By way of the TCEQ's interest in here, in this issue, yes, there is an ongoing challenge with who is held accountable under the MPDS and TPDS system. Right now, it's City of Liberty as the recipient of these flows from our customers, but ultimately as the discharger to the state. We care about the Trinity River watershed. We care about our compliance with the parameters in our permit, and we want the Commission to know that. This is not something new. This is not something that's popped up in the last few days, in the last few weeks. And so, Commissioners, we would ask that you consider the fact that waiting and strategic patience has not yielded solutions. We've got our separate litigation dealing with amounts owed under a contract for excess fees, excess flows. Whenever they come in above the 2-time peaking factor, there's supposed to be a volumetric service charge. We're not asking you to get into that. The appellate court in Beaumont has a plea of the jurisdiction in front of it. That's not before the Commission today. We're asking for regulatory solutions. So with that, again, Commissioners, we would ask that you would You would deny the petition, but if you issue an order that it come with some strings attached, some requirements, so that we can move past what we've seen by way of neglect, just to be frank about the system. So with that, any questions, we certainly would entertain them.
Colleagues, any questions for Mr. Vassar?
No, thank you.
Thanks.
Thank you, sir.
you.
Appreciate it. We'll take up any other interested persons. Ms. Smith, is anyone signed in to speak on this?
No one else
item?
has signed in.
Okay, let's hear next from the Executive Director's Office.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Benjamin Worms, and I'm a staff attorney with the Litigation Division representing the Executive Director. I'd like to go over a few points by way of background in this issue on why the Executive Director did not issue an order without a hearing in this matter, as well as some history of Texas Water Code 13.041 that may be informative to this discussion. Both TCEQ and PUC have authority to issue an emergency order under Texas Water Code 13.041. Each agency may issue these types of orders under different circumstances, but based on the information in the request filed, neither TCEQ nor PUC are ideally situated to issue an emergency order on this issue. The dispute, as we've heard, between Ames and Liberty is at its core a contract dispute over the interpretation of a specific section of the contract that has been in place since approximately 2000. The current dispute has been ongoing since at least 2016 and under active litigation in district court since 2018. This is an issue that would better be handled through mediation or other alternative solutions, rather than to have a state agency insert itself into what at this point is a private contractual dispute. However, the history and use of 13.041 may provide some clarity as to when an emergency order under this statute may be used. There is precedent for TCEQ issuing an emergency order to compel the provision of sewer service through an interconnect due to a contract dispute. This was the underlying issue the last time TCEQ issued an order under 13.041. That order compelled the City of Columbus to provide an interconnect to the Glidden Freshwater Control District. However, the statute has changed substantially since the time of that order. In October of 2009, when the Glidden Columbus order was issued, only the TCEQ could issue emergency orders under 13.041. The language of the statute at the time was that an emergency order could be issued, quote, if service discontinuance or serious impairment in service is imminent or has occurred, end quote. In 2013, 13.041 was amended by House Bill 1600 to transfer the emergency order powers under the statute from TCEQ to PUC. PUC obtained the language under which the 2009 Glidden Columbus emergency order was issued. In 2019, Senate Bill 700 was enacted, which again amended Section 13.041 to include the current language, allowing TCEQ to issue emergency orders to compel retail public utilities to provide service or provide an emergency interconnection, if, quote, necessary to ensure safe drinking water or environmental protection, end quote. TCEQ has not yet issued an order under 13.04 subsection H1 or H2. The language under which the last emergency order under 13.041 was issued can now only be exercised by the Public Utility Commission. Finally, when the 2009 emergency order was issued, TCEQ also had the authority to set rates for the temporary service. Under the current rule, TCEQ would have to request that the Public Utility Commission establish reasonable compensation under subsection I. I'd also like to note that no current environmental issue was alleged in the request from Ames. The request describes a potential for an environmental hazard if multiple conditions are met, if Liberty takes the action stated in the January 5th, 2022 letter, and if Ames has no ability to find any alternate solutions. Given this, the ED staff did not feel that it yet had the grounds to issue an order under the new 2019 language that TCEQ is authorized to use. I do want to illustrate that there are situations under which the authority to issue an emergency order under 13.041 would be clear and complementary to the authority granted to the PUC in 13.041 subsection D. For example, if a utility which produces water from a single well suddenly had their well run dry, TCEQ could issue an emergency order under 13.041 to compel an interconnect with a neighboring utility, which could provide safe drinking water to the customers while a new well was drilled. In a case like this, the power to issue an emergency order under 13.041 is most appropriately used to respond to an emergency situation where the order is necessary to ensure safe drinking water or environmental protection that is threatened due to an emergency situation. I'm available for any questions. We also have staff of the Office of Water who can answer any questions related to the technical, permitting, or engineering matters that are implicated here.
Great, thank you, Mr. Worms. I don't think I have any questions for you right now. Any
No, thank you.
questions?
None, thanks. Appreciate the
All right.
background.
Mr. McWhorter.
Good morning. This is a difficult one from the perspective of my office based on the limited information we had available to review. But when all is said and done, OPIC would support the issuance of an emergency order along the lines that Mr. Vassar outlined with a limited duration and with the focus, of course, being not on the contract issues, but on what's necessary to protect the environment and protect safe drinking water, and hopefully with the assistance of ADR to see if there are some solutions that could be worked out. We recognize, again, emphasizing that I believe any order that would be issued should be of a limited duration, and if there's not solutions moving forward quickly, that a date be set in the not too distant future for the hearing to revisit the emergency order and perhaps have an evidentiary hearing to develop the issues more fully.
Thank you, Mr. McWhorter. Colleagues, any questions for Mr. McWhorter?
Thank you.
Okay. Well, here's my take. We have a financial dispute. We have a dispute over how to read a contract. We're going to read this as an and or an or. And the parties' negotiating postures now threaten environmental harm, in my view. I don't think it's a remote, tenuous thing. It seems pretty immediate. July 1 is nearly upon us. Ames might have foreseen that Liberty would take this step 4 years ago when Liberty filed suit. Liberty put Ames on express notice 6 months ago of its intent to suspend service. And yet Ames made no other arrangements and waited to the 11th hour to seek this emergency relief. For its part, Liberty seems not to have anticipated the volumes of wastewater that it might receive under its contract with Ames. So I think there are, colleagues, quite a few should haves or could haves in this matter. But setting those disagreements aside, I don't think they're before us. This commission's purpose is to protect the environment. We haven't seen an order from the courts to do that. PUC has declined to weigh in. The executive director, for its own purposes, has not. So I think it leaves it to us to ask that question and take that action. In my view, Ames has met the requirements for an emergency order to compel continued service. Among other things, I think they've established sufficiently for today's purposes that the order is necessary to ensure environmental protection. So I'm going to propose that we do issue an emergency order. Because we didn't receive the petition until so late, we didn't have time to notice a hearing, so we should set a hearing date to affirm or modify or set aside the order that I'm recommending today. In terms of the amount of time we should afford under this order, I think we have a statutory limit at 180 days. That would be the outside. We heard the City of Liberty request 60 days. I think realistically, looking at the calendar, we're not going to be able to have a hearing on this until late August, I think. Late August. So that's where I am on it. Commissioner Lindley, what do you think?
Thanks for that. Yeah, this one was really tough. I'll just say that I'm in agreement. I think today what's before us, it's appropriate to compel Liberty continue to provide the sewer service. But I would strongly caution Ames from expecting the commission to renew an emergency order for an additional 180 days whenever, if, assuming we move forward granting an emergency order. I think 180 days is plenty of time. I would be supportive of a shorter time frame. And so if that's something you gentlemen wanted to discuss, well, I'll just say I would prefer shorter than 180 days. I guess since I'm suggesting I have to toss out a number, I'm sitting here thinking, I mean, to me, end of August is 60 days away, right? So maybe we add a little bit of time onto that, but not 180. So I would say, I don't know, 90, 120 days. That's kind of where my head's at right now, but tossing that out for discussion. So I would agree with you, but I would like to shorten the time frame to get this done.
Commissioner Janeka, what do you think?
I really appreciate that. I think I'm in agreement with where Commissioner Lindley is in terms of shortening it. I had some open questions remaining from, after hearing from the testimony, the feasibility of pump and haul services, the practicality of that, I think could still be a little more filled in. I wonder if y'all might entertain one question to City of Liberty, perhaps, whether City of Ames, whether they've actually investigated any contracts. What are the practicalities of that? What's the timeline of trying to obtain that? That does more to try to answer the question for me of what shorter time frame looks like, if that's the most credible option.
Mr. Nesloni, if you want to take a swing at that.
I honestly have no idea. We've really focused on trying to fix our existing system and get funding for that. I don't know that that would be feasible, but I'll look at it and have the city look at it.
I appreciate that. I would encourage you to be prepared to speak to that if we do proceed and we have a hearing. I think that's something I would think is important for me to understand.
Okay.
I just have one quick question too, actually. I think I know the answer, but just to confirm, what I don't want to happen, I think we'd all agree, is this to continue to be a problem, right? An issue of, Ames exceeding the monthly and/or daily exceedances. Is Ames growing? Is it it's a tiny city, right? But I don't want this to, in 2 years, Ames have 200 more people. That's all. It would probably take significantly less than that to, have higher potential, discharge sent to Liberty. I don't want this to continue to be a problem, if that makes sense. I know it's hard to predict the future, but.
I don't think it's growing like that would cause a problem. We do have some issues that we want to talk about with Liberty about the area that we're serving, because we think we're serving, or that's what I've been told, in some areas that really that are in the ETJ of Liberty, and that increase, specifically they mentioned something about a country club to me that's been put in that right now Ames is serving, has increased, or allegedly, the flows from what they were before.
Yeah, thanks. I appreciate that.
Thank you, sir.
Thank you.
I think if 90, in terms of a shortened length, wouldn't pose problems for the scheduling, we think that hearing could exist. I think that, or 120 would be a comfortable number for me.
That would get us through a likely hearing date on this, and the only downside is it might come back to us sooner and we would get to talk about it again, but
I think it would get you through the agenda date, but if you decided at that agenda that it needed to be referred to SOA, you might want additional time.
Would an extension be possible at that agenda date?
I would need to look at if we could do it at that agenda date. They can apply for another 100, up to another 180 days. The order could be extended once.
What if we hedge a little bit and go with your high number, 120 days?
I can do that.
I'm good.
Okay.
But the hearing will be end of August. That's still what we're shooting?
The hearing before the commission,
Yes, thank you. Yeah,
so for a modifier set aside.
okay.
I think we may be ready for a motion, no?
I could attempt one
So-
with a 120-day would be the only alteration from what I've got. I move that we issue an emergency order compelling the City of Liberty to continue providing sewer service to the City of Ames for 120 days that complies with all statutory and regulatory requirements of the Commission to ensure the protection of the environment in accordance with Texas Water Code Chapter 26, Texas Water Code Section 13.041H1, and 30 Texas Administrative Code Chapters 35 and 291 of TCQ's rules. The City of Liberty is a municipality and a retail public utility as defined in 30 Texas Administrative Code, Section 291.3, subsection 14. The City of Liberty has obtained Certificate of Convenience and Necessity Number 20056 to provide sewer service. The City of Ames is a municipality that receives wastewater treatment services from the City of Liberty pursuant to a contractual agreement issued on March 14th, 2001. The City of Liberty informed the City of Ames by letter dated January 5th, 2022, that it would cease accepting wastewater flows on July 1st, 2022. On June 16th, 2022, the City of Ames filed a request for emergency order alleging the City of Ames has no means of obtaining sewer service other than from the City of Liberty and requesting that the Commission issue an emergency order to compel the City of Liberty to continue to provide sewer service to Ames pursuant to Texas Water Code Section 13.041H and 30 Texas Administrative Code Section 35.202. As of today, June 29th, 2022, the City of Liberty has not rescinded its January 5th, 2022 letter. The City of Ames currently does not have an alternative in place to provide sewer service on or after July 1st, 2022. Pausing for a correction.
I just wanted to make sure that this list of items, which sound like findings, are meant to be findings and in the order.
Thank you. I will, I confirm that I specify these are
Okay.
findings to be placed in the order. I didn't specify that before launching into this list.
Thanks.
Thank you. So this is the eighth statement or finding of this list that I'm reading. It is reasonably foreseeable that the City of Liberty's suspension of the City of Ames sewer service would result in an unauthorized discharge of wastewater under Texas Water Code Section 26.121. The City of Liberty is located in close proximity to the City of Ames and is capable of providing sewer to the City of Ames through existing lines, and the City of Liberty should be compelled to continue to provide sewer service to the City of Ames for 120 days that complies with all statutory and regulatory requirements of the Commission to ensure the protection of the environment in accordance with Texas Water Code Chapter 26, Texas Water Code Section 13.041H1, and 30 Texas Administrative Code Chapters 35 and 291 of TCQ's rules. Finally, I further move that we direct the Office of General Counsel to draft an emergency order with findings of fact, conclusions of law, and ordering provisions consistent with the Commission's findings, conclusions, and discussion today, and include in the emergency order a hearing date and time of August 24th, 2022, 9:30 a.m. to affirm, modify, or set aside the Commission's emergency order.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the adoption of revisions to new technology implementation grant program guidelines for grants RG 484.
And we'll hear first from the Executive Director's Office.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Nate Hickman with the Air Grants Division, and with me here is Sierra Redding with the Environmental Law Division. We have had the opportunity previously to discuss the Diesel Emission Reduction Incentive Grant Program. Today, we're looking at the New Technology Implementation Grant Program, which is also a program of the Texas Emission Reduction Plan administered by TCEQ. The adoption of the proposed revisions to the program guidelines would incorporate changes to the requirements for this program under Chapter 391 of Texas Health and Safety Code as enacted by House Bills 2361 and 4472 of the 87th Texas Legislature in their recent regular session. The revisions expand the types of projects that TCEQ may consider for grants for a new technology project to reduce emissions from oil and gas sites and operations. Staff also respectfully requests permission to make non-substantive changes to the revisions to comply with Texas Register requirements. And I thank you very much for your consideration, and we are available to answer any questions you have.
Thank you, Mr. Hickman. I have none. Colleagues, any questions?
No questions, thanks.
Likewise, none. Thanks.
Ms. Smith, has anyone signed in to speak?
No one has signed in.
Mr. McWhorter?
OPIC agrees with the Executive Director that proposed revisions to the New Technology Implementation Grant Program guidelines are needed for consistency with applicable statutory requirements. We recommend approval of this item.
Colleagues, I agree. We're just implementing legislation here. I'm ready to move forward with adoption.
As am I. I would move that we adopt the revisions to the New Technology Implementation Grant Program Guidelines for Grants, RG 484, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you, Mr. Hickman.
Thank you.
Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code, executed during the previous quarter. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Insurance Counsel. For the record, my name is Trenton Davis, purchaser of the Financial Administration Division. I have with me Chris Gobert, Procurements and Contracts Manager of the Financial Administration Division. We are representing the Executive Director. This item contains the material changes made to contracts and purchases for goods and services between September 1, 2021 through November 30th, 2021. Reported material changes include extensions of the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more. In accordance with Section 2155.088 of the Government Code, the Executive Director presents these items for your consideration. I am available to answer any questions you may have.
Thank you, Mr. Davis. I have none. Colleagues, any questions?
No questions, thanks.
I appreciate the report. Thank you.
Ms. Smith, has anyone signed in to speak?
No one has signed in.
And Mr. McWhorter, what did you find?
OPIC recommends approval of the resolution acknowledging material changes to contracts for goods and services as presented by the ED.
And colleagues, I agree. I've reviewed the changes and am ready to move forward with them.
I will make the motion that we approve the Executive Director's issuance of the Executive Director's proposed resolution that acknowledges the material changes to contracts for goods and services in accordance with Texas Government Code, Section 2155.088, for the period of September 1, 2021 through November 30, 2021, as described in the TCEQ Interoffice Memorandum to the Commissioners and Executive Director dated June 29, 2022, in docket number 2022-0611-MIS.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you, Mr. Davis. Ms. Smith, when
Thank
you're
you.
ready, please call the next item.
Item number 5 is the consideration of gifts and donations of $500 or more in value given to the TCEQ, submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Mr. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yan Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Tran. I have none. Colleagues, any questions?
Questions?
Is anyone-
Likewise, none.
Sorry, has anyone signed in to speak?
No.
Mr. McWhorter?
OPIC recommends approval of the resolution acknowledging acceptance of gifts and donations as presented by the Executive Director.
Thank you. I agree. I've reviewed these and think that we should acknowledge them.
I do as well. I will move that we approve issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated June 10th, 2022, docket number 2022-0596-MIS.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you, Ms. Tran. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is old business item 1 and new business items 6 through 32. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are old business item 1 and new items 6 through 32. The total assessed administrative penalties are $633,473, with $92,579 deferred, $88,034 applied towards supplemental environmental projects, and $444,526 to the general revenue. The Executive Director respectfully requests a remand of item 19 because staff received notice yesterday that Ralph A. Menard II has passed away. The order is against Mr. Menard and Menard II LLC, and Mr. Menard is also the sole managing member of the LLC. We are requesting approval of the remaining items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I don't have any questions right now, but I had a couple observations that I just wanted to share with the Office of Compliance and Enforcement and my colleagues. Item 6 comes back to us by way of a settlement. I appreciate the parties entering into that. Number 9 comes to us on citizen-collected evidence, and this is a team effort. This agency can't do it alone, so we really appreciate citizens being engaged and where we can build an enforcement case on citizen-collected evidence. We appreciate that. And then for the Office of Compliance and Enforcement on item 32, I'm concerned about the what the compliance picture may be there moving forward. You don't need to address that unless you'd like to, but I would just urge the Office of Compliance and Enforcement to continue monitoring that regulated entity closely. Colleagues, any questions or comments for the Executive Director?
I was going to make a similar comment on item 32, so appreciate you saying that.
Ditto to both the item 32 comment, but also the citizen-collected evidence on the earlier item. I agree that's a very worthwhile thing to cheer when we see it done successfully.
Agreed, yes. Ms. Cordell, seems like we're all interested in item 32, so if you have anything that you want to say about that, feel free. If not, I think we're pretty clear in what our instructions are to OCE.
From the Office of Compliance and Enforcement perspective, of course, we will be closely monitoring this order and ensuring that we can get a hold of the respondent and continue to just address those violations.
Thank you. Colleagues, any other questions for Ms. Cordell at this point?
None.
Okay. Ms. Smith, who has signed in to speak?
We have several people who have signed in on items and are available for questions. And those items are old business 1, new business 6, 7, 12, 31, and 34.
Okay, here to answer questions, but not asking to speak.
I believe that's correct.
Okay. And who is signed in on old business one? Because I do have some questions on that.
We have Ms. Katie Moreno, who is virtual.
Good morning, Ms. Moreno. How are you?
Good morning. I'm well. How are you?
I'm doing well. Thanks so much. Thanks for being here today. I asked for this item to be continued over so we could have a conversation about it. And what I'm interested in, or let me begin with why it caught my attention. I understand there are numerous pending enforcement actions, and I wanted to get a sense of your view of the issues. What are the problems out there? What is the entity doing to address those problems? What resources, personnel, or investment are you all bringing to bear to address the issues? I just want to have a better sense of where you are. So I'll ask that broad question, just open it up for your response.
Yes, sir. And thank you for the opportunity to be able to discuss it. With me, part of my staff, I also have Hilda Sebesta and Vinod Jamie with me. I'm going to let Hilda address your questions at first.
Thank you.
Yes, my name is Hilda Sebesta, environmental engineer for Phillips 66. We would like to reiterate that we have implemented corrective action items, and we have not had recurrence of any of these same root causes since implementation. Specifically for incident 343850, an internal memo was developed to ensure future project installations will include the following: simulation of the maximum electrical load to flag any potential setting issues that we have, commissioning process to compare as left and issue for construction settings, and documentation of actual differential currents. All of these corrective action items are intended to identify any relay setting discrepancies and correct them before potential power failures. For incident 346007, a procedure was developed to route refinery gases out of our flare gas recovery system during periods in which this compressor is shut down. We've also had learning from the incident communicated to applicable instrumentation personnel, and they've conducted audits of similar compressors in this area to ensure no other abandoned wires were present. These corrective actions have been intended to minimize flaring in the event of a compressor shutdown, as well as to increase awareness among applicable personnel and make sure that we have no abandoned wires that could lead to similar compressors at risk. For incident 348430 and 346420, the wet gas compressor control scheme was modified to ensure it was not operating in choke flow, and a compressor and pillar was redesigned to have the correct frequency. These corrective action items are intended to prevent fatigue failure and tripping of that compressor on high vibrations. And then for incident 348430, we've also developed internal checklists and streamlined our chain of communication for responses to the agency.
Thank you for that. And let me ask: is these actions we're talking really about sort of discrete corrective actions related to particular violations, which is appropriate because we're here to talk about a particular agreed order? And my question was a little bit, or what I was looking for, if you have an answer, is a little bit broader explanation to put these violations and the ones that are the subject of other pending enforcement orders into a larger context, if there is a larger context. So, for example, with the actions that you just outlined, is that are those corrective actions, corrective measures being undertaken with existing personnel and investment, or is this part of a broader effort? If there's anything that you can offer in terms of putting all of these enforcement orders in some context, that might be helpful.
This is Katie Marino again. For all of these, I would say that first, whenever we have an incident, we do look at it for the individual equipment that was involved, and we try to identify the root cause. but we do translate those corrective actions to other similar equipment or future equipment that may be installed. So we look to be sure that the equipment itself is repaired and it won't happen again on that equipment. We look for similar equipment where applicable and make sure that we don't have the same issues waiting to happen on that equipment. Then when necessary, as Hilda discussed, there were some training opportunities to be sure that the incident was communicated and any learnings were passed on to the people that operate the equipment or that do maintenance on the equipment to ensure that we don't have those problems elsewhere in the facility as well.
Okay, that's helpful. So, Ms. Moreno, is it fairly routine, just as a matter of internal practice or policy, that y'all will do a root cause analysis and then prescribe particular corrective actions?
Yes, sir. We have policies internal that at different points it triggers us to do different levels of investigation. So for every emissions event that we have, we are following up with a review, after action review or a management review to get all parties involved together to discuss what happened, the learnings, and how to prevent it from happening either in that unit, on that equipment, or elsewhere within the facility. Okay,
and that's for every emission event, you said?
Yes, sir.
Okay. Well, thank you. I really appreciate that explanation of how you're approaching these violations. That helps me understand a little bit better. Colleagues, any questions for the regulated entity?
No.
I appreciate the answers that you've provided today, and I think that it's always helpful whenever we have, as this item before us, there's a number of other items coming behind where when you're looking at root causes, I'm also eager to see if any of those cross across multiple events, and that would be helpful for us to hear about. I know it's difficult to come and address the matter before you responding to just those matters, but I appreciate your effort to go a little beyond that. Thank you.
Thank you, Ms. Moreno. We appreciate you and your team being with us today. Ms. Smith, is anyone else signed in to speak?
Not to speak.
Okay. Mr. Mc... Oh.
Sorry about that.
All right, Mr. McWhorter.
My office reviewed these items. We support the remand of item 19 for the reasons laid out by the ED, and we recommend approval of the remaining orders as recommended by the executive director.
Thank you for that. Colleagues, I'm in the same place. I think I'm ready for a motion.
I agree. I can attempt a motion, or?
I've got one prepared.
Okay, go for it.
I would make the motion that we remand item 19 to the executive director and adopt old business item 1 and new business items 6 through 18 and 20 through 32 as recommended today by the executive director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, call the next item, please.
Item 33 is the consideration of the monthly enforcement report, and the executive director's staff is here to report.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2022 through April. There were 684 effective administrative orders issued, and of those, 102 contained supplemental environmental projects. These orders assessed a total of $8,872,391 in penalties, with a payable amount of $5,356,068. $2,097,264 are to be paid towards supplemental environmental projects. 9,498 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,261 enforcement action referrals have been received. There are 1,875 pending administrative orders with 429 cases that are on the backlog. 208 cases are pending at the Attorney General's office for representation in district court, and 8 judgments have been issued. 2,071 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2020, 2021, and 2022. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none.
No
Any
questions.
questions?
I appreciate the report.
Is anyone signed in to speak?
No one is signed in on this item.
Mr. McWhorter?
I don't have any questions. I appreciate the report.
I do too. Ms. Cordell, thank you very much. No action is necessary on this item, so Ms. Smith, I'll ask you to please call the next item.
Item 34 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 113, Standards of Performance for Hazardous Air Pollutants and for Designated Facilities and Pollutants, Subchapter C, National Emission Standards for Hazardous Air Pollutants for source categories. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Melanie Nealon with the Air Permits Division. With me are Terry Salem and Ashley Rich with the Environmental Law Division. The proposed rulemaking would incorporate by reference revisions adopted by the United States Environmental Protection Agency to maximum achievable control technology and generally available control technology standards. A public hearing will be offered on this proposal in Austin on August 11th, 2022. Staff respectfully recommends approval to propose the publication of and hearing on amendments to 30 Texas Administrative Code, Chapter 113, Standards of Performance for Hazardous Air Pollutants and for Designated Facilities and Pollutants, Subchapter C, National Emission Standards for Hazardous Air Pollutants for source categories, Federal Clean Air Act, Section 112, 40 CFR Part 63. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we're available to answer any questions.
Thank you, Ms. Nealon. I have none. I'm just grateful you didn't have to cite all of the standards under Chapter 113.
Ditto.
Colleagues, any questions for Ms.
No.
Nealon?
None. Thank you for diving into plumbing the depths of these federal rules to make sure they're consistent in ours.
Has anyone signed in to speak?
We had somebody signed in, but who does not want to address the commission and is apparently not on the line, so.
Okay. Mr. McWhorter.
OPIC recommends approval for publication of and hearing on the proposed amendments to the Commission's Chapter 113 rules as presented by the Executive Director.
Thank you. I agree, colleagues. We want to be in step with the current federal standards, and I think we're ready to put this out for comment.
I agree. I would move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 113, as recommended by the Executive Director.
I second the motion.
Motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you, Ms. Nealon.
Thank you.
Ms. Smith, when you're ready, please call the next items.
Items 35 through 38 are for executive session, and the commission will meet in executive session in Building E, Room 211S at, you want to give us 5 minutes? 10:38, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 074, to take up and consider matters pursuant to items number 35 through 38 as posted and noticed.
With that, the time is 10:33, and we are in recess.
The commission met in Building E, Room 211S for closed session from 10:41 until 11:09 a.m. on item numbers 36 through 38 as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. This agenda is adjourned. The time is 11:12.